Most families believe a will protects them, but in reality, a will often guarantees probate, court delays, and public records. Today, I'm going to show you the 8 differences that matter and the exact setup that keeps your family out of court and in control. I'm Anthony Brister, estate and tax attorney. My team has walked countless of families through probate and trust administration. I've seen what works in practice and what costs families time, money, and privacy. Today we're going to cover probate, the timeline, incapacity, distribution options, protection for your heirs, privacy, pour-over wills, and the essential documents that most people skip. First, let's go into probate versus no probate. But before we even talk about wills or trusts, let's talk about the word that most people only hear when it's already too late, and that's probate. Simply put, probate is a court process that decides what happens to everything you owned after you pass away. But in practice, it's rarely simple. It's paperwork, attorneys, hearings, waiting times, and expenses, all at the exact moment your family is trying to grieve. The purpose of probate, though, is to make sure your assets transfer properly, your debts are paid, and the law is followed. The problem is, it takes time and control out of your family's hands and puts it in the courts. And that's where planning makes all the difference, because with the right structure, you can decide whether your estate ever enters probate at all. So let's break this down. There are really only 3 ways an estate can transfer after someone passes. Either you did nothing, you have a will, or you properly funded a living trust. And so here's the concept. The 3 ways an estate can transfer is intestate, that's without a plan. State law and the judge is going to determine what happens. Your will, your wishes, but you still go through probate. And then the revocable living trust, that's actually funded. It's a private administration, no court order to transfer trust titled assets. And a will is instructions to a judge. A funded revocable trust is the authority your family can use immediately. And if you only remember one point, remember this. Second, let's talk about the timeline and cost reality. Again, simply put, probate is a process with notices, waiting periods, inventories, hearings. It's not fast, and the professional fees accumulate with the complexity. With a funded revocable trust, your successor trustee steps in and follows your written instructions without the court's micromanagement or attorneys stepping in. Third is a trust helps you plan while you're still alive. This is a key idea. Wills operate after death, while trusts operate now and can cover incapacity. So if you're hospitalized or you lose your capacity in some way, a funded revocable trust plus a financial power of attorney lets your named trustee manage the accounts, pay your bills, and protect your assets without a guardianship proceeding. Fourth, let's talk about how distributions actually work. With a will, you must get court approval, then you distribute and close the probate. With a trust, you choose the structure. It can be outright, the simple way. You can have age-based milestones, for example, distributions at 25, 30, 35, or intervals, 10% every 5 years. Or you can have a long-term / dynasty where you want to preserve assets and distribute for health, education, maintenance, and support. If you want your assets to last and the behavior to matter, the trust gives you the tools to do that. Fifth, there are real-world protections for your heirs. Trust language can help shield against predictable life events, such as special needs, avoiding jeopardizing means test benefits. There's divorce risk, so keep distributions a separate property and require separate accounts or sub-trust. It can protect you from creditors or bankruptcy and allow withholding until claims pass. addiction or instability can permit testing, treatment conditions, or limited distributions. A will can't do this elegantly. A trust can, without turning your family issues into a public court fodder. 6, trusts are more private. A will plus probate equals a public file of assets, lists, beneficiaries, fights. It's all searchable, while a trust administration is private. If you value discretion for your family, your business interests, this alone justifies a trust-first plan. And ask yourself, do you want this process to be public or private? Okay, now for 7, and here's a plot twist. You still need a will. Even with a revocable living trust, you still sign a pour-over will. If you miss retitling an asset, the pour-over will directs it to your trust, one beneficiary, a cleaner process, and fewer contests. You want to add a no contest clause to deter courtroom adventures. And lastly is you'll want to round out your plan with these other documents. So a financial power of attorney for incapacity coverage, a medical power of attorney and HIPAA release to talk to doctors and follow your wishes. You want a living will or an advance directive. This is the pull the plug document to give end-of-life guidance. You want guardianship nominations for minors and a personal property memorandum. Who gets what kind of knickknacks and personal effects you have. You want to retitle your accounts, real estate, update beneficiaries, and most problems come from missing the funding steps, not the trust document themselves. For example, if you had 2 homes in different states, brokerage and business interests, with only a will, that has to go through 2 states' probates, have months of delay. With a funded trust, your successor trustee can take over, the rents stay over, and they can transfer assets easily. I put together a free estate planning guide with a funding checklist and goes over all the essential estate documents that you need. You can grab that at bristertaxlaw.com or in the description below. Estate planning isn't about paperwork. It's about execution and leaving your family protected. A will speaks to a judge, but a properly funded trust equips your family to act and gives them lasting instruction. And if you're serious about staying out of court, keeping your affairs private, start with a guide, and when you're ready, book a short call to see if you're a good fit. We'll tell you exactly what it takes and whether we're the right shop to build it. Go to bristertaxlaw.com, and if you found that this video was helpful, please like, share, and hit that subscribe button to get updated more. And share this with someone that you think needs it. Thank you.